Breaking news coming out of Georgia. The judge in Donald Trump's RICO case has rejected his attempts to have the charges thrown out based on free speech arguments. In a decision that came down less than an hour ago, Judge Scott McAfee wrote, "The allegations that the defendant's speech or conduct was carried out with criminal intent are something only a jury can resolve." Christy Greenberg is a former federal prosecutor, former deputy chief of the FDNY Criminal Division, and an MSNBC legal analyst. MSNBC legal correspondent Lisa Rubin is with me as well. Unpack this for me. What else did the judge have to say?
So one of the things, Chris, that the judge is saying here is you're not being prosecuted just for making statements that are false. You're also being prosecuted for willfully and knowingly making false statements that impact governmental functions. For example, some of the charges here have to concern impersonating public officers, meaning the fake elector scheme, or forging documents, as in, again, the fake elector scheme, signing those certificates, the elector certificates. That is what Fani Willis and her team say constitutes a forgery under Georgia law. He's saying there might come a point in time where after the factual record is developed, this will be unconstitutional if they can't show those elements. If they can't show that it was willful and with knowledge and that it affected a governmental function, you can come back to me because I'm not foreclosing your ability to raise these challenges at the appropriate time. But for now, on the allegations by the DA's office in the indictment, which I, as a judge, are obliged to take as true at this time, no First Amendment problem.
So, Christy, that means the free speech argument isn't necessarily dead?
Not at least at this stage. As Lisa points out, we haven't gotten to the trial yet, and a jury may find, as a question of fact, that the defendant's speech or their conduct here did not have the requisite criminal intent, and therefore it would not be criminal. But that's separate and apart from their First Amendment arguments. Again, if it's criminal speech, it's not protected by the First Amendment. So at least the judge is saying at this stage, pre-trial, I'm not dismissing the charges on First Amendment grounds.
All right, so Lisa, I want to read a statement we just got from Trump's lead counsel, Steve Sato. President Trump and other defendants respectfully disagree with Judge McAfee's order and will continue to evaluate their options regarding the First Amendment challenges. It is significant that the court's ruling made clear that defendants were not foreclosed from again raising their as-applied challenges at the appropriate time after the establishment of a factual record. Where does the Georgia case go next? Does this, at least for now, mean no delays?
I think it does mean no delays for now, particularly because he's left that door open. But, Chris, I want us to differentiate between leaving the door wide open and leaving it open a hair. I would say that this is more akin to a hair because on the facts as we understand them now, is it likely that the jury will not find that these were knowing and willful false statements? Probably not. But Steve said I was correct. There is a door that's open. It's open a hair. It doesn't sound like they're likely to appeal. But again, he's leaving that door open for himself as well.
As we said, Christy, this wasn't the only case that was impacted today. Let's go to the New York hush money case. The former president tried and failed there to get the trial delayed by trying to raise the issue of presidential immunity. Why didn't that work?
Well, because he sat on his lawyers sat on their hands and they didn't raise it sooner. As the judge noted in his denial of this motion, the defendants had ample notice of the fact that there were certain statements that Trump had made when he was president on social media and in public that were going to be used as evidence at this trial. He was well aware that he could have raised the defense of presidential immunity and that was available to him. And he chose not to. He chose to raise it 17 days before the scheduled trial date. That is way too late to be raising this issue. And so really the court said you had an opportunity, you knew this was available, and by not raising it at the proper time, you don't get to raise it now.
So the immunity, Lisa, that argument was to try to keep certain statements that Donald Trump had made about Michael Cohen, Stormy Daniels, out of the trial. Why does he seem so intent on blocking that evidence?
He's intent on blocking that evidence because it shows criminal intent. It is sort of like after the fact intent. or consciousness of his guilt, judging by the fact that through some of those statements, they include tweets, he is trying to intimidate Michael Cohen from participating in the law enforcement process and cooperating with law enforcement. That's why he wants those tweets kept out, because prosecutors say that they evidence a consciousness of guilt.
Hey everyone, MSNBC has a new and improved app. You'll get real-time alerts and analysis, live blogs, in-depth essays, video highlights, and the best 2024 election coverage. Download the new MSNBC app. Here's how to do it. You tap on the App Store on your phone. You hit search on the bottom right corner. You type in MSNBC. You click on the MSNBC app. You click on Get or the cloud icon and enjoy it.